And so we encourage you to as well type any questions you may have throughout the presentation in the chat box. Simply click chat at the bottom of your screen to access the chat box, and we'll address your questions as best as we can. If you wish your question to be anonymous, I would say then please send your message to Jennifer directly, and she will maintain your anonymity. With that, housekeeping items out of the way, I'd like to introduce our guest speaker, Brock alumna Jennifer Philpott, who graduated from the Goodman School of Business, BBA Co-op, in 2016. Jennifer provides advice and representation to employers, management, and individuals on a wide range of employment, labor, and human rights issues. Jennifer is a passionate advocate and advisor for her clients and strives to deliver solutions-oriented services tailored to their unique objectives and needs. Originally from Niagara Falls, Jennifer, as I said, is a Goodman School of Business alumna. While at Brock, she received the university's Co-op Student of the Year Award for her work developing an accessibility compliance plan and training program for her colleagues at a large provincial ministry. For her commitments to leadership and community service at the university, Jennifer was awarded the prestigious Spirit of Brock Award at Convocation. I just want to thank you all for attending and sorry, I'm starting to read other notes there. So I will now just pass it on over to Jennifer. Thank you, everybody.
Thanks, everyone. And thanks, Darren, for the introduction. Nice to see everyone here today. So as Darren mentioned, I practice exclusively in workplace and employment law. And the focus of today's presentation is very topical, given that in about 2 hours, the Premier is set to make an announcement that may foreshadow what's going to be happening with sort of the continued reopening of the province and vaccinations, boosters, and probably going to impact a lot of people's holiday plans. So workplace law in 2021 and probably 2022 has not been a dull moment. And I'm looking forward to talking to all of you today about some of these key considerations, whether you're an employee or an employer, about what you need to know about going back to the workplace in Ontario. So just a few things before I start. The general disclaimer that anything I say today is not legal advice. It's only legal information. Of course, if you are looking to implement any of the policies or take any of the steps that I talk about today, you should consult with a legal advisor, an employment or labor lawyer, depending on your workplace, before you take any action, just to make sure you're following all rules and regulations accordingly. As well, the focus of my presentation today, just for the sake of time, is going to be focused on Ontario employees only. I think everyone here is tuning in from Ontario, but that's going to be the emphasis of today's presentation. And I'm going to also focus on employees governed by the Employment Standards Act. There is, of course, separate legislation for employees that are working in federally regulated industries. But again, there's just not enough time. And quite frankly, every topic that I want to talk about today could be its own presentation all in itself. So with this in mind, I'm going to share my screen. So everyone just bear with me while I do that. Okay. All right. Let's see if I can get this going. Okay, perfect. So I hope everyone can see my screen and the PowerPoint presentation. If something is wrong at any point, please just tell me and I'll try and troubleshoot as best as I can. So, all right. So we've already had a lovely introduction. Thank you again, Darren. But my contact information is on the screen in case anyone is looking to get in touch with me. And of course, you can just visit the website of my firm, Goulart Workplace Lawyers, for more information too. All right, so today I'd like to talk about the following 3 topics: hybrid and remote work and how those arrangements work, what those policies look like, and how you can, I guess, work with one if you're an employee or implement one if you're an employer. What returning to the office looks like, so some key considerations, again, for employees and employers. And then just briefly on some recent changes to the Employment Standards Act 2000, some of which are born out of the pandemic and what we've experienced working remotely, and others that were just sort of a long time coming. And you may know that there's been recently new legislation tabled that's received, as we call it, royal assent, and is going to impact the ESA directly, but we'll touch briefly on that. So we'll hop right into hybrid and remote work, and specifically hybrid and remote work policies. So when we're talking about hybrid and remote work policies, the main thing here is to consider who is going to be eligible for remote work. Many of you have likely been working remotely, or you're tuning in today from your home, just like I'm giving this lecture today from my home. And the key thing is that not all jobs will be eligible for remote work. Some folks work in industries where they have to physically be in the workplace, and others, like law, for example, are a bit more flexible. So if you're developing a workplace policy, and just to back up, actually, if you don't have a policy in place, now would probably be a good time to implement one. Most of us went remotely essentially overnight in 2020, and everybody just sort of adapted to the circumstances that were in play at the time. But this is looking like it's going to become, again, the new normal for the foreseeable future as we adapt to changing circumstances and dealing with variants. I know some folks have gone back into the office. I'm usually in about 3 days a week myself. But if you're even thinking about having employees continue to work either on a hybrid or fully remote basis, putting a policy in place is really key. And again, that policy should clearly identify who is eligible for remote work, so there's no confusion. You could also consider, as an employer, making satisfactory performance a requirement for eligibility, and that if there are any performance issues that exist with your employees, addressing them, of course, but reserving the right to recall the employees back to the workplace. There should also be clear and defined expectations for what work looks like outside of the office. So setting hours of work and schedules, having timelines for the completion of work, compliance with any and all existing policies that were in place prior to going remote, if it's new, to make sure that you're not running afoul of any existing workplace policies and procedures. This may include as well how overtime hours are going to be dealt with. A lot of employees have been working hours far beyond what they normally would have, simply because of the convenience of being at home. And quite honestly, at least for most of the last year, there wasn't a lot else to do other than work. So whether or not it was a communicated direction, or folks just felt that they were home and they had nothing else to do, or rising workload, that's also a factor too. You want to make sure as an employer that you're putting these parameters in place so there's no confusion at all. And we'll actually touch a bit about working beyond normal hours later on. So there should also be a plan in place to protect confidential information. If you're working in an industry that it has any kind of client data, records, things of that nature, the policy should outline how you as an employer expect your workforce to deal with that information. The workforce itself should also be suitable, or the workplace, I should say, from home or remotely, wherever you are, should be suitable to work and consider any privacy requirements. Rule of thumb, maybe don't have meetings in public at a Starbucks or out in the open. If you've got loose files, try to keep them in a secure location. Protect all soft copies of documents, so perhaps installing more secure software and remote desktops, things of that nature, and making documents password protected and encrypted. And for any hard copies, having policies about who can take files out of the office, whether there should be a sign-in, sign-out procedure, how documents that are no longer necessary will be disposed of. Back in the day, if you worked in any kind of typical office setting, there might have been a shredding box or a physical shredder to take sensitive information to dispose of it. Most employees don't have shredders at home, and things of that nature. So making sure those policies exist that cover all these little ends and angles is very important, particularly when you're dealing with sensitive information and data. Some other considerations include workplace safety and the WSIB. So the term workplace is defined very broadly under Ontario's Occupational Health and Safety Act. And WSIB has affirmed since the pandemic has started that employees and employers have the same rights and responsibilities when they work from home or off-site as they did when they worked in the employer's main office or any of their satellite offices per se. And this is still ongoing, and I expect that it will continue to be the case. There's also special considerations where a workplace incident happens at home. So, if there's an injury or anything like that, that could be covered by your WSIB coverage if you are registered, of course, with WSIB. Things like that still apply. So making sure that employees, for example, are using ergonomic equipment and have proper setups. If that's part of your scheme in the office, you may wish to have that built into the remote workplace too. And that kind of goes hand in hand with cost considerations. Many employers just sent their employees home with their laptops, their maybe monitors if they had them, any other hardware, things like that. Again, overnight, really, last year. Workforces and their employees really were not equipped to have fully complete home offices. Some people were working and probably still are working from their kitchen tables, for example. So if you're an employer, you might want to consider how expenses are going to be dealt with and whether there's going to be any reimbursement. Is equipment still going to be provided? If you switch to a hybrid model and now your employees are back in, is the expectation that they bring their work equipment that they may have taken with them back to the office? And will the employer provide any sort of reimbursement or amount, salary, what have you, for equipment for the home? And also, just as a segue, my cat has now jumped up on the table here from where I'm presenting. So she might make an appearance, but if you hear a cat, it's because I now have company for the presentation. So things like that. As well, internet service, that's something else that we've seen. Clients have come to us and asked us, do I need to cover any kind of high-speed internet or give an allowance for things like that, or cell phone bills, hardware, stationery, all those things. So these are somewhat afterthoughts, but they are important to consider. And of course, the ability to compel the worker back to the office is key. Remote work for some may be forever. It may have been the permanent situation for some of you before the pandemic, but it's unlikely that for many employees, remote or hybrid work going forward will be permanent. I mean, we'll have to see. But of course, it's prudent for an employer to consider having a provision in any formal policy that gives it the ability to give the employees advance notice and require that they return to the workplace when it is, of course, safe to do so. And again, you could also have a duration built into that policy too, that would ultimately cover any concerns about, how long it's going to last. Right now, I think it's best to be flexible, but of course, we don't know what's going to happen. And so putting a hard date in might be difficult, but time will tell, really. Okay. Oh, I don't know if I skipped over. I don't have a bullet in here, but I wanted to bring up surveillance just because it's relevant. And some of you may have, come across this if you've been reading articles, or your employer may have even mentioned to you that they're putting in workplace monitoring program. So generally speaking, employees have the opportunity and the right, I should say, to know if they're going to be monitored by their employer. There is privacy legislation that governs this. Some of you may be familiar with PIPEDA. And so if employees are being surveilled, it is best practice to alert them to this, that there is software in place that's monitoring their performance, and to let them know the purpose of why that software has been implemented as well, and what, if any, consequences there are, especially if any disciplinary consequences might arise from how they're using employer equipment and what the software is actually tracking. All right. So I'm going to now talk about some key things to think about when we're looking at returning to the office, which again, as of today, I don't know that many people are optimistic that we're going to be fully back in the office anytime soon. And again, it depends on your employer and the nature of your work. But these are some of the key considerations or questions that I receive in my practice from employer clients and also from employee clients. The first one is, can my employer ask me to return to the office? Can they ask me to come back? And generally speaking, the answer is yes. So for very few employees, remote work will be a condition of employment. This is something, you have to ask yourself, is it a fundamental term of my employment? We expect that employees may raise challenges if they ask to stay remote and their employer says no, that there may be some, legal battles that come up dealing with this, and asking the question of, did working remotely for the last 18 plus months constitute a fundamental change to the terms and conditions of the employment agreement? And right now, there's no precedent that I've come across that clearly spells out yes or no in this situation. But that being said, we're going to have to wait and see. Of course, if you take a position during the pandemic, and if remote work is built into it, it very well may be a condition of employment. But this is something to consider, and for the most part, employers have the ability to compel their employees to come back to the workforce, pending that it's safe to do so, and that all health and safety obligations are being met under Ontario law. And of course, that there's accommodation where necessary. If for some reason you can't return to the workplace because of maybe perhaps childcare issues, health issues, or other reasons, it's best to have this conversation with your employer, and the employer should also be frank with the employees as well about when it expects them to come back. The most prudent thing to do is to give as much notice as possible in those situations. So something that some of you may be familiar with is back in the beginning of the pandemic, think back to March of 2020 and the spring of 2020, many employers were making very difficult decisions about whether or not they could keep employees on. For many employers, in order to function and operate and deal with potential losses, they had to make difficult decisions about laying off workers and reducing the size of the workforce or reducing hours. And so with that in mind, Ontario introduced legislation called the Infectious Disease Emergency Leave. And what this effectively has done is to deem any employee whose hours or wages were reduced due to the pandemic to be on a leave, similar to a layoff. And this leave has been extended numerous times throughout the pandemic. I believe it's now been extended into the summer of 2022. And so we've sort of been using that as a gauge to see where the province thinks things are headed. But of course, an employer can call back their employees either before the end of this leave, before it expires, or sooner if they need employees back working for them. And many have already done so, and we've assisted clients in my practice with that as well. But some key considerations just to keep in mind in case this impacts you at all. You should give adequate written notice detailing the return to the workplace. Similar to a recall with any other layoff, but with a few added pieces. So again, this is a very fluctuating situation. We don't know what's going on with complete certainty in the pandemic. And so the recall may change based on the situation in Ontario, case numbers, what public health is saying, and all those other elements. And so you want to be clear as an employer, speaking with your employees, that they know that this is the situation and that it's subject to some flexibility and flux. Of course, you also want to detail the processes that are already in place in the workplace. If you have workers that are working and what you're going to be doing to bring those laid off workers back, what they should expect in terms of health and safety policies, vaccination policies, which we will get into, and all of that necessary information to make sure the workplace is safe. And to develop those policies as well and implement them if you haven't already done so, certainly before the recall of your employees. A key question that's on every employer's mind right now, or at least the employers that have engaged in sending employees off on unpaid infectious disease emergency leave, is whether or not this constitutes something called constructive dismissal. And so constructive dismissal usually occurs where an employee, their employment contract is upset by a unilateral change made by an employer. And some employees may consider themselves to be resigning, but on the basis of constructive dismissal because the employer has changed a fundamental term of the employment. What the legislation that was implemented was meant to do, in many cases, was to try and minimize the exposure that employers had by having to put employees on these layoffs. And so far, we've had dueling decisions at the Superior Court of Justice in Ontario that address whether or not this infectious disease emergency leave actually constitutes a constructive dismissal at common law, and whether employees can sue for damages as a result. One decision said that it did. Another decision has said that it does not, and that decision is being appealed to the Court of Appeal, and we're expecting that to be heard sometime in the spring of 2022. So there are other defenses available to employers, of course, if they're looking to call workers back, and if they find themselves facing a claim from workers challenging their employment on the basis of constructive dismissal. Employers, of course, have the express right in a contract or policy, if one is in existence, to lay off their employees. So if that's included in any kind of employment agreement or policy, the employer may be able to rely on that. There's also an implied right to a layoff, either based on past practice or of course, a novel argument. I mean, we were and are in the middle of a pandemic, and these are, I hate to say the phrase, but unprecedented times. And so employers have had to really think on their feet and adapt and do make difficult decisions really in this pandemic. So those are some of the other defenses that might be available. As well, there's a defense of condemnation. So typically in a layoff situation, an employee will have a month or so to claim constructive dismissal after a material change has happened in their agreement. If the employee is on infectious disease emergency leave for months at a time and claims benefits related to COVID-19, so think Wsib or CRV, for example, but then only claims constructive dismissal once they're recalled, the employer might be able to argue that they've condoned the change. And finally, there's also an argument that could be made for frustration of contract, of course, through neither fault of either party, but simply because of the circumstances surrounding COVID-19 currently and into the foreseeable future. Something else we've seen in the workplace is COVID-19 testing policies. These are becoming more prevalent. In the beginning, we really weren't sure of the efficacy and effectiveness of rapid tests and PCR tests, but of course, these are both proven to be relatively effective, or at least indicators that an individual should seek medical attention and leave the workplace. So an employer has the duty to protect the health and safety of its workers and also the workplace. And really, this is a balancing act here. When you're thinking about implementing testing policies, this is a key consideration to make because some individuals may be resistant to undergoing COVID-19 tests, but overall the employer has to balance those two key considerations when making really any decision, but certainly in the specter of COVID-19. As well, there are provincial and federal programs available now for employers to access rapid tests. We do this in my workplace, and it works quite well to have access to those rapid tests, although I understand right now that there is some issue with individuals being able to access rapid tests, and that's been a subject of discussion on an ongoing basis and will likely be into 2022. As best practice, employers should bear any costs associated with testing. And this is sort of the direction we're seeing in decisions that have been released on this issue in terms of workplace policies for COVID-19 testing. There have been some vaccinate or test policy challenges, but most of these are being done in the private arbitration context or in labor arbitration context as well. And of course, if you're dealing with a labor situation, the collective agreement will govern that relationship. And we're not going to get too far into that today. But I did want to alert you to the fact that these decision makers are taking into consideration, all the obligations that an employer has to their workforce and to what can be done with the tools that we have to reduce the spread of COVID-19 in the workplace. And the fact that, employees who come to work and who may be symptomatic and or positive are potentially putting the lives of their coworkers at risk, and that they need to be reasonable in dealing with recommendations or requirements that their employers have put in place. So those are just some things to think about when you're looking at COVID-19 testing policies. So I'm sure everyone has been waiting with bated breath for vaccination policies, because this is the hallmark of employment law, I feel, in 2021, or at least toward the end of this past year. We've known vaccines were coming for a long time, and I think there's a lot of confusion, not just from employees, but from employers too, about what it really means to put a vaccination policy in place in the workplace. And many of you may work in environments where this has already been discussed or could inevitably come down the pipe in the new year. So there is a difference between mandatory vaccines or mandatory vaccination versus mandatory policies. Recently, in about the last few months or so, there was a regulation released that advised businesses that they now have a legal requirement to implement vaccination policies in jurisdictions where the medical officer of health has given any kind of advice, recommendation, or instruction about implementing a vaccination policy. Now, this doesn't mean that vaccination itself is mandatory, and quite frankly speaking, it is difficult for an employer to forcibly compel their employee to be vaccinated. It's simply stating that there's now a legal requirement to actually put a written policy in place in certain jurisdictions. I can say for sure that in Toronto, Peel, Halton, Niagara, and the Hamilton regions, there have been statements from the medical officer of health advising that workplaces put these policies into place. There's no specific mention in the regulation as to the content of the policy, so that is a bit flexible. Some of these regions, their public health units have provided guidance to employers on what can go into a policy. Of course, if you're going to implement a policy, it's my recommendation that you speak with an employment or labor lawyer who can help you tailor that policy to your workplace and make sure that nothing is missing. But of course, there's no mandate to make mandatory vaccination, except in certain industries. And quite frankly, the decision, which we'll get into in a second, about whether or not to just encourage versus to actually make vaccination a condition of employment, has really been put on to individual employers and industries. At least in Ontario, the government isn't really taking direct action on this. So when you're looking at putting a vaccination policy in place, if you haven't already, there are certain things to take into consideration. So first, all vaccination policies should start by encouraging vaccination at a minimum. You can use language confirming that vaccines have been proven to be safe and effective in terms of fighting COVID-19. You may wish to consider even providing incentives. We saw some employers doing this in the beginning. Some of you may be familiar with vaccination mandates in the US, where there were many incentives, free Krispy Kreme donuts, and that wasn't really from an employer, but you saw those in the news of companies encouraging folks to be vaccinated, and employers too, offering large bonuses or other benefits to their employees as an incentive. We've seen that in Canada as well, but just not on the same scale. As well, as I mentioned, you'll want to decide whether vaccination should be a condition of employment for your workplace, or again, simply just a recommendation. This is one of the most common questions we've received from employers during the pandemic. Under the Occupational Health and Safety Act, as I've mentioned, employers have a duty to take all reasonable precautions to protect the health and safety of their workers, and of course, to balance the rights of individual workers with the overall health of the workplace. Some employers have taken the position that this allows them to make vaccination mandatory and as a condition of employment, particularly in environments where employees are working in close quarters or cannot work remotely. And so accommodation becomes very difficult. Or where you're serving vulnerable populations, I think, long-term care facilities, working with children, maybe daycares, private settings like that. Those come to mind, of course, and anywhere else in the healthcare industry. If an employer is considering making vaccination a condition of employment, not only should it be put in the policy, but it should also be in any future employment contracts for new hires. Again, of course, consult with your employment lawyer when doing this, just to make sure that you haven't overstepped in any way and that you're acting in accordance with all Ontario legislation governing employment. You'll also want to state that the vaccine should be approved in Canada. I believe there are 4 approved vaccines in Canada to date. This may change going forward as we have more clarification and other vaccines could potentially become available. Another relevant consideration is to make the policy broad enough that it considers the fact that employees will need boosters. We're seeing this already. I believe there's an announcement coming out at 2:00 today from the government about booster shots. And so we did at one point think that, it was 2 doses of an approved vaccine in most instances that was required. Now it's looking more like it might be 3, but this is a bit of a fluid definition. So keeping it open and including that employees may need to receive boosters in accordance with policy or any employment agreement is good practice. But without clear legislation in place that mandates vaccination, it's unlikely that employers will be able to force their employees to be vaccinated. So companies need to be prepared to accommodate where necessary, as well as to implement measures in the event that an employee cannot or chooses not to be vaccinated. Accommodation, as I've mentioned several times already, is critical. In Ontario, we're seeing 2 main avenues for accommodation under the Ontario Human Rights Code. The first is for a medical reason. Employers have a duty to accommodate individuals under the code, including if they have any kind of illness or disability. Of course, there is an onus on the employee to work with the employer and provide proof to an extent that is reasonable of the need for an accommodation. And some things you could do in this circumstance, if the position allows, you could have employees work from home. You could have them work in an isolated area of your facility, if the facility, of course, is big enough to accommodate that. Modify work duties, require the use of personal protective equipment, even above and beyond what is required at the present time, or have the employee take a leave of absence. The other and less frequently used protected ground of discrimination in these accommodation issues is religion. You're less likely to encounter an employee who brings this forward on a religious ground, because simply many religions, at least not to my knowledge, have come out saying, or sorry, not many religions to my knowledge, have come out with the heads of those religions saying that vaccines are not acceptable for members of their congregations. So this is less likely. What you are possibly likely to see is someone choosing not to vaccinate based on personal preference. And they may not be able to back up either reason, medically or religious, to support their decision not to vaccinate. The Human Rights Commission has come out with several very useful resources on its website, and I encourage you to look at those that deal with this issue. And they've expressly stated that personal preference is not a protected ground of discrimination. And so they're going to be looking for medical proof or religious proof of some kind in order to have an accommodation that's brought forward on those grounds. But of course, where there is a valid accommodation required, an employer has an obligation to accommodate the employee up to the point of undue hardship and should take steps to do so. And of course, that's a situation as well where you'd be benefited by speaking with an employment lawyer to make sure that you've met all your duties under Ontario legislation for accommodation. I've already mentioned that employees may choose not to vaccinate and what are some options available to them. While testing is becoming more commonplace, more and more employers have access to tests and will test their employees on a regular basis if they choose not to vaccinate. You may also wish to consider putting an employee on a non-disciplinary leave. More serious steps could include unpaid leave or termination, but you need to be careful in terms of termination. And if an employer is prepared to implement non-disciplinary alternatives, the policy should always reserve the right to take the necessary steps to protect the health and safety of workers up to these more serious outcomes. There's no precedent yet on whether or not termination for just cause or with cause would be considered valid. At this time in the Ontario employment law community, the general discourse has been that if an employee refuses or does not become vaccinated under a policy, that this will not rise to the threshold of termination with cause. If an employer ends the employment relationship on this basis, then they must give the appropriate termination package in accordance with Ontario employment law, again, for those employees that are regulated under the Employment Standards Act. Something interesting that's developed over the last few months is Service Canada has released a new record of employment code for dismissing employees who either don't show up to work because they're not going to comply with a vaccination policy or who refuse to vaccinate in spite of a mandatory vaccination policy, by which I mean one that requires employees to be vaccinated. And so there's a specific code now that employers can fill out if that occurs, but Service Canada will likely contact you as the employer for more information about why you chose to use this code. Something else that is important to consider, and I've had many employee clients ask me about this as well as employer clients, is privacy in collecting this information. You'll recall when we received, if you've been vaccinated, the little printouts that you received on the day you were vaccinated, those have a lot of sensitive information. And in some cases, employers have been asking for that for their records, which they are entitled to do to an extent. Of course, those little sheets had health card information. Overall, they confirmed whether or not you were vaccinated, which is personal medical information as well. And so if an employer is collecting any proof of vaccination, they should take all steps to ensure that it's kept in a secure location. In a policy, it's prudent to name the position or the department, usually human resources, that will have access to this information, and also to state when even if it has to be a bit vague because of the ongoing and fluid situation with COVID, when these documents will be destroyed and whether employees will be notified of their destruction. Because to ensure that you're complying with privacy requirements, it's prudent to destroy the information after it's no longer necessary for the purpose of the original policy. And of course, there's also the post-vaccination rules. So just because you're vaccinated, as we all know now, does not mean that you are immune against COVID-19 and the ever-coming variants that we've encountered. The best practice is to follow all public health guidelines concerning personal protective equipment, sanitization of surfaces, and personal hygiene practices. And so the policy in place should speak to this, and the fact that just because you're vaccinated doesn't mean that the rules as we have them don't continue to apply. And it's looking like we'll be dealing with masking bylaws for quite some time going forward, and I expect that public health will continue to issue the same guidance that they have to date. So this brings me to the almost end of the presentation, which thankfully doesn't deal with COVID-19 as much as the rest of the presentation has. And I know that those are a lot of heavy topics and they cause a lot of mixed feelings and just sort of anxiety around how we're going to best protect our workplaces and each other as we navigate this time. And so recently in Ontario, many of you may have noticed that there are some changes that are being made to the Employment Standards Act. The provincial government has really been in the media a lot lately announcing some of these changes, some of which affect Wsib, temporary foreign workers, and immigrants to Canada who are seeking employment, particularly in the province of Ontario, as well as temporary agencies and certain regulations around them. But there are two changes that have been adopted now under the Working for Workers Act that I want to discuss because I think they're topical and relevant. The first is the end of non-compete clauses. So some of you, if you're employees, or certainly if you're employers, may have built in non-compete clauses to your employment agreements that would have applied to employees post-termination or post-resignation. And usually these employees or these employment clauses were restrictive on where employees could work post-resignation or termination and for how long. Oftentimes, these clauses were very difficult to enforce. Employers were putting them in out of self-preservation and protection, but they were regularly thrown out by courts. And so this change really is just a reflection of how the legal system has dealt with the existence of these non-compete clauses after employment on an ongoing basis. So the change now introduces a prohibition only on clauses that attempt to prohibit competitive activity after the employment relationship has expired. There are two exceptions to this. So in the sale of a business, this rule will not apply, as well as executives and executive level employees as defined by the legislation. So think your C-suite level employees. And usually these provisions were included as some sort of protection for the employer by bringing on employees who have a great fiduciary duty, like C-suite executives would, to the company and to ensure that their interests are protected. And interestingly, that second exception was added as the bill underwent review in the legislative process at Queen's Park. So it did develop a bit over time with consultation. And just in case you were wondering, non-solicitation clauses are still okay. So those have survived this change and continue to be permissible in employment agreements and enforceable. And lastly, the final topic I want to bring up is something that's just generally an interesting topic, but certainly was spurred by the pandemic, which is right to disconnect legislation. Canada and Ontario are relatively behind on this front. We've seen jurisdictions in the US and particularly in Europe, most recently and most notably Portugal, introduce this right to disconnect legislation, and quite frankly, with a little bit more teeth than what we now have in Ontario. And again, spurred by the pandemic, the Minister of Labour has specifically mentioned this, that they received and were in consultation with employees who had been working longer hours from home, while engaging in remote work and hybrid work, and being contacted by their employers outside of the traditional hours of work. So this new prohibition, it is to some extent a prohibition, but this policy will apply to employers with more than 25 employees. However, it is quite broad. The gist of it is that employers have to implement a policy with respect to disconnecting from work so that their employees are to be free from the performance of work. What is the performance of work? Could be many things. Receiving emails, taking video calls, doing telephone calls, delivering, reports or projects, anything where the employer or management would be engaging with the employee outside of, I suppose, the normal parameters of their workday. But again, this is very broad, and there's no specific guideline in the legislative changes that actually says when an employee can or has to disconnect. So it will really be up to employers, working, of course, with council, to develop these policies for their workplaces that meet the requirements as stated out in legislation, but that also are tailored to the unique work environments that everyone works in. I know for me, working in law, a policy like this would be somewhat difficult to implement, given the fact that we don't always have regular 9 to 5 hours, and that's an expectation within employment in the legal profession, for example, that most employees know when they're becoming lawyers or working in law firms. So it will be interesting to see how different institutions create policies that are tailored to their needs, and how this legislation perhaps develops over time. But for now, employers who meet these requirements need to have policies implemented by June 2nd of 2022. And I've got a bullet point up there about the Employment Standards Act. So we'll have to keep in consideration when we're developing policies, myself as an employment lawyer, but certainly employers, what the limitations are in the maximum work hours under the Employment Standards Act. Of course, 8 hours a day and 48 hours a week. So it will be very interesting, and all of these changes to the ESA are I think, welcomed, particularly by employees. They've been generally employee-oriented changes, and that being said, right to disconnect legislation is certainly topical, as I've mentioned, and I suspect that other provinces will follow suit. But I guess the answer to everything with law is sort of stay tuned and see how things pan out when they're actually in practice. And so I've talked for quite a bit, so I'm happy to open the floor to questions if anybody has anything they want to ask pertaining to what I've talked about today, or if there's something that's maybe tangentially related. I'm happy to take your questions now. And I don't know if there's been anything in the chat, because
there's one question in the chat anyways.
Okay, so the question in the chat says, with remote work, I have heard of people starting to consider having multiple full-time employers. What risks would the employee have if they were considering an arrangement like this? So that's a great question. And there's my cat's tail. That's an excellent question, because some employees have started to do this. I've heard rumors of it or rumblings of it as well. I think the main consideration, if you're an employee, you need to be sure that you're not running afoul of anything in your employment agreement with your original employer. The non-compete provision that I mentioned earlier and the prohibitions on those non-competes, those apply for after the employment relationship has ended. They don't necessarily apply to create a prohibition for non-competition during employment. And certainly if you're employed by competitive employers, there may be prohibitions in your agreement before entering into something like that. So if you're an employer and you're trying to prevent employees from engaging in competitive employment while working for you, certainly speak with an employment lawyer about what policies could be put in place, as well as what provisions of a contract could be put in place to protect your interest as the employer. And that is especially so in cases where the employee has a fiduciary duty of any kind to their employer. And if you're the employee, certainly be careful, because you might be treading into difficult territory here by doing that. And you may actually, like I said, run afoul of your employment agreement. So it's touch and go with that. In the sense that employees need to be careful about what they're entering into and shouldn't just enter in blindly. Of course, it's always on the employee, if they feel comfortable, to speak with their employer about why they might be taking on multiple forms of employment. But again, the question considers full-time employment, and that would be very difficult, I think, to accommodate, and not just for the employer to be considerate of whether that arrangement would work. But I'm not sure how someone does 2 full-time jobs at once without the possibility of error in at least one or the other. So those are all things that come to mind, but that's a great question. And of course, my default answer to everything is always talk to your employment or labor lawyer. Certainly, if you're trying to implement any policies, or even if you're an employee, you can seek information from an employment lawyer who can guide you as to how you should conduct yourself, just so that you're not in violation of any employment agreement. But it's always best to have that legal advice and be proactive. And I don't know if anybody else has any other questions. I know we're nearing the end of the presentation today and the time that we have together, but certainly I feel like in the next few weeks or so, I'll be inundated with questions from folks as we're adapting to the changes. And of course, this is a lot of information. So what I will do actually is I'll put my next slide up. If I can, if it will go, I think I've clicked out. Won't seem to go to my next, oh, there we go. So my last slide here. So you can connect with me and of course my firm if you have any questions. The email address for the firm generally is on the screen, as well as the link to sign up for our newsletter on our website. We send out newsletters about every quarter, sometimes a bit more frequently if there's been changes in legislation or anything else that's come up that's new and noteworthy. We also post links to the webinars that we run on our YouTube channel. And of course, you can connect with us on LinkedIn as well, where we share our blogs and other information about events. But yeah, employment law is an ever-changing area, and certainly never a dull moment, or at least in the last few years. And I suspect going forward, that will be the case. And if you have any questions at all, feel free to speak with me, contact me. I'm happy to answer. And I also work with a team of excellent, very skilled and seasoned lawyers who have lots of experience drafting the policies we've talked about today, of course, working with employment agreements. And nobody likes litigation, but if litigation is necessary, our team is equipped to do that too. Yeah. And I don't know if anybody has any other questions. I'm happy to take them, but certainly feel free to reach out after otherwise if you prefer to do so.
All right, well, yeah, I guess, well, anyways, I was seeing that there is none, but
Yeah.
you know, I just want to take the time to thank everybody for attending. And thank you to Jennifer for providing us with you know, this great information. Hopefully everybody found it valuable, and she sort of says it's ever constantly changing as well as we move forward. And even this afternoon, things will probably change with an announcement. So I know here at Brock, we're constantly changing too with some ways that things are going and what is being recommended. So hopefully everybody, you know, stay safe out there, you know, throughout the next little while, and hopefully we get through all of this sooner rather than later. As mentioned, we did record the webinar, so if anybody wants to take a look back at it and rewatch any parts, you can. We'll have that up on demand, hopefully within a week anyways. We'll provide that to you all in an email anyways with it. You can always catch any of our past webinars as well at brocku.ca/alumni/webinars. And later today, you'll also receive a survey. So if you wouldn't mind taking the time to fill it out, it helps us with our webinar programming. So, and if there are no other questions.
Doesn't look like it, but I also threw a lot of information out in a very short time.
Then yeah, that will conclude our webinar for today. And again, thank you, everyone.
Thanks, everyone.
Okay, have a great day, everybody.
Take care and stay safe. Happy holidays.
Happy holidays.